you all for braving the cold and coming out to see the forum for our judicial candidates for Branch 4, right? Correct. Before we begin, I'm going to introduce a few people that are here tonight. I'm going to start with our candidate for Circuit Court Branch 6, Zach Witchow, who's going to come up. He's going to start us with the Pledge of Allegiance, but I do want to make a note that he is in a race against a hardcore liberal who had a fundraiser just recently with the Supreme Court candidate for the Democrats, and we got to get behind Zach. So WISRED is preparing for that. So Zach, I'll let you lead us in the pledge.
All right, you please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Amen. Thank you, Zach. All right, I'd like to introduce just a few other people that are here. A couple other candidates. Scott Wagner, running for Branch 1. At this point appears unopposed, so we're very pleased.
I would echo Chris's thoughts about Zach. It's very important for somebody who's opponent of leaving Zach early and hard. He's one of the finest men I know. I had the privilege of getting to know him a lot over this campaign. He will be an excellent judge. He was a fine lawyer, the highest of integrity, and it's really important that we keep someone who believes God immediately endorses their candidate out of that office. So
Amen.
please do whatever you can to support Zach.
Yes, that's great. We also have the famous Judge Doro with us from Branch 2 tonight.
So really important.
That's great. We also have Maria Lazar from the Court of Appeals. We also have Monica Paz here, Clerk of Courts. We have a couple local officials here too, and being that we're in WISRED time, I'd like to introduce them as well. We have Mary Larson from the Pewaukee School Board. A real champion for WISRED. We appreciate you, Mary. Terry Tesh, Supervisor, Genesee. Unfortunately, Brad Schimmel couldn't be here tonight. I think he's feeling a little under the weather, but we do have Ethan here from Schimmel's campaign. Ethan, I don't know if you want to come up and just say a quick hello or a word or two.
Absolutely.
Tell everybody to take a sign.
Sounds good.
Well, clearly I am not Brad Schimmel. My name is Ethan Bailey. I'm Brad's political director. And actually, I am from Fort Wayne, Indiana. And until today, I thought winters in Fort Wayne were kind of cold. And this morning, I stepped outside the house, and I went, holy cow, you guys are nuts living up here. In all honesty, though, I don't need to talk about Brad too much. You guys know him. You guys know what he stands for, and you guys know the importance of this election. Right now, we just won big. President Trump was just inaugurated. In fact, Brad was there in D.C. He told me that he got back today about 1 a.m., was in court all day, and went home not feeling the best. So when you guys are ready to get involved, I know we talked a lot about it. All you got to do is just go to schimmelforjustice.com, get signed up. We'll get you plugged in, whether it's knocking doors, making phone calls, writing letters, putting up yard signs, whatever it is. Yard signs are here. Make sure to take one on your way out. We just got to get them up all over the place. The earlier the better. But I will be in the back of the room here for a bit. So after this great forum, come up and talk to me. Benjamin's also in the back. I know a lot of you guys know him. So just come up. We'd love to chat with you. Thank you.
Sounds great. Thank you, Ethan. Also, Roger Adams from the Village of Waukesha, Supervisor. I also see Dylan Newman, who popped in from Vernon back there, Village Trustee. Real quick, a couple people are also here that I'd like to thank. I'd like to thank Kimberly Campbell in back, who's been helping. She's on the WISRED Executive Committee or Vetting Board. over to Kevin, who will introduce our candidates and tonight's forum.
All right.
Thanks, Kevin.
Thank you, Chris. Good evening, Judge Shamor. Good evening, David. Good evening, everybody. Thank you for coming out tonight. I will be moderating this debate this evening. I don't know who was here for the DA debate. Did anybody see this? We had a few people here. Okay, so it's going to be the same format as last time. What's going to happen is, at first, each candidate's going to have the opportunity to give an opening statement. It will be 3 minutes long. The order in which candidates will do so will be determined by random draw. Then we will get into the question part. What we will do is I have 9 questions that have been prepared to which each candidate will respond. Each candidate will have 2 minutes to respond to each question. After each candidate has provided a response, the candidate who answered first will then have a 30-second rebuttal. The other candidate then will have a 30-second rebuttal after that. The candidates will alternate being the first to answer questions. The candidate that first answers the initial question will be the candidate that provides their opening statement second. The topics, I don't know if everybody's got a handout, but the topics are going to be on the handout. I won't go through them right here, but we'll hit them as we go. After that, we will have an opportunity for audience participation in a candidate forum. Now, this is going to be a little bit different than the DA debate. The DA debate was a little bit more public-facing. The position's a little more public-facing. A judge is beholden to a lot of different ethical rules. There's certain questions they cannot answer when posed to them in a candidate situation. So people will have the opportunity to provide questions. Kathy Pape is going to hand out some note cards. You'll be able to write them down if you have questions in the audience, and then I'll take a look at them after we're done with our first round of questions. And I'll utilize my legal knowledge to see if these are ones that can actually be posed to the candidates. If so, we'll come back and we'll have a maximum of 3 questions to be asked. After that, the candidates will then have an opportunity for closing statements. So that is the rules here. And yes, I am an attorney. I realize I'm not dressed like one, but I figure it's below 0, so we can relax the dress code a little bit tonight. To start, we are going to have a random draw here. Keith Best has taken the opportunity to pick a number between 1 and 10, and you can each try to guess which one it is. Whoever comes closest will go first. This is not like The Price is Right. You can go over and still have your guess count. Go ahead.
Pick a number between 1 and 10.
Pick a number between
Okay.
1 and 10. You're on my right, so you're arbitrarily going first.
I'm gonna go with 4 because I like even.
4.
I'll take 7.
4. The number is 8. So, Mr. Moss, you'll be providing your opening statement first.
Thank you.
One last thing. Just to announce, when they're answering their questions, when they have 30 seconds left, they'll get the warning, the yellow card. 30 seconds left in your first answer. And then the red means stop. So I'm the official timer. And I also double as a sergeant at arms, so don't anybody get out of line.
All right, whatever you're ready, Dave.
All right, thank you. Good evening, everyone. Thank you very much for braving the cold and coming out to tonight's debate and forum and giving me an opportunity to speak to you all tonight. I sincerely appreciate the interest that you have in this election, and I appreciate the interest that you have in hearing from me and Judge Shaneborn. I am here to ask for your vote. I am running to be the next judge, elected judge for Branch 4 of the Waukesha County Circuit Court, because I believe that values, experience, and a deep respect for the Constitution are what will carry the day in this election. For the past 25 years, my experience has been as a state criminal prosecutor here in Wisconsin. Protecting our community, I've handled thousands of cases. I've tried well over 100 trials. Everything from violent felonies to misdemeanor traffic cases to homicide cases. Everything from election integrity to public integrity. The bulk of my career, in fact, was 15 years as an assistant attorney general. I led the election fraud task force at the Department of Justice and literally wrote the book on election fraud prosecutions as an assistant attorney general. Under Brad Schimmel's leadership, I was promoted to deputy director for the complex criminal litigation unit, where I supervised a number of different units, including sexually violent persons commitments and other general and violent felonies. I also provided training to prosecutors and law enforcement all around the state of Wisconsin, providing the tools to police and prosecutors to aggressively investigate and go after their cases.
For the past 5 years, I've also taught 100 of our circuit court and court of appeals judges in a digital evidence boot camp for judges specializing in Fourth Amendment and cyber issues for the flagship program put on by the Judicial Education College. A judge should be a leader, and I have been a leader in my career. Through prosecutions and trainings, I've worked alongside law enforcement day in and day out, from start of investigations to close of criminal cases. And that's why I feel very honored to announce that I have the endorsement of all the major police associations in the area, including the Waukesha Deputy Sheriff's Labor Union, the Milwaukee Police Association, and the Waukesha County Police Chiefs Association, which, by the way, is the only official endorsement of the police chiefs in Waukesha. They know that I understand the unique challenges they face and will always approach cases with the seriousness that they deserve. I am also proud to have the endorsement of Brad Schimmel. I've known Brad for about 2 decades. His endorsement is a testament to my shared commitment to justice, protection of the community, and judicial restraint, constitutional values. I'm honored to have endorsements of other conservative judges like Jack Melvin and Shelley Grogan, conservative district attorneys like Eric Toney and Sue Opper. These public servants have known me longer ago than just July. They've known me for my career, and they trust me to be a good conservative judge in Waukesha County. You will get in me a hard worker and a dedicated public servant, and I ask for your support in April. Thank you.
Thank you. Hello, everybody. Thank you for coming tonight. I'm Judge Bridget Shaneborn, Waukesha County Circuit Court Judge for Branch 4, and I'm on the ballot on April 1st, and I would love your support. Waukesha County needs judges who protect the community, who support law enforcement, and who recognize their limited role in the government by following the rule of law. I am a tough on crime and rule of law judge. Prior to coming to the bench, I served as a prosecutor for over 16 years, investigating the most serious crimes that were committed in our community, including members of dangerous drug cartels, including gang members who engage in street gun violence and drug trafficking, and including individuals who sought to deprive our elderly out of their hard-earned savings. It was a privilege to serve my country, protecting the public in that fashion, and it's been a perfect transition to the Waukesha County bench, where I continue to do that. Before I go too much further, I should tell you that Evers appointed me to the bench after my opponent Dave Moss and I applied. Maybe he thought that my Native American heritage and my gender meant that I would be liberal. He couldn't have been further from the truth, and you do not have to take my word for it. I have the endorsement of individual police chiefs who see the work that I am doing to protect our community every day. I have earned the endorsement of conservative judges like Jennifer Doro, Randy Koshnick, Michael Boren, and a host of others, because they see the work that I've been doing on the bench and they want me to keep doing that job. Why am I running? Because I love my community. Because I love my job. I've raised my kids here. Waukesha County deserves a place to live, play, and work safely. It deserves to be protected from becoming Milwaukee County. I am the tough on crime, rule of law judge. I ask for your support because I am the most qualified candidate for Branch 4. Thank you so much. I look forward to sharing more of my qualifications with you tonight, as well as to answering your questions.
All right, thank you, Judge Shaneborn. Okay, as I indicated previously, because you went second in your opening statement, you will be the first to answer the first question.
Great.
So the first question this evening, it relates to use of outside resources in assisting performing judicial duties. The question is, judicial resources are limited, and the practice of law is becoming more and more specialized, especially in civil court. Judges are being asked to decide matters that are often a first impression to the judge personally and would be well beyond the experience of the vast majority of practicing lawyers. What role do you envision that outside legal resources, including continuing legal education, consulting with disinterested attorneys, or even the appointment of referees in complex matters, will play in assisting you performing the duties of circuit court judge.
Thank you. So I should start by acknowledging the fact that I have civil experience. I practiced as the asset forfeiture chief in the U.S. Attorney's Office for approximately 4 years before coming to Waukesha County. And I also was a civil law clerk working on constitutional issues for the judges in the Eastern District of Wisconsin, including Judge Randa and a host of others. So I am aware of some of the challenges that are posed in civil litigation. I would say this: in all courts, we start with a rule of law. That is our guiding light. We then next turn to precedent and to case law. If that is not good enough, there is room for relying on external sources. However, we need to be very careful about what they are. First of all, we need to make sure that they're vetted, right? That these are studies that have been conducted, that have some supportive background, that these are reliable sources of information. Second, we need to acknowledge the role of a judge in our community, which is very limited. We are not fact finders. We cannot convene studies. We cannot collect data. We cannot reach conclusions. That is for the legislature to do. So judges have to be very careful. They can respond to novel issues as presented by the parties, but they cannot go off and do this on their own and go outside their limited scope as judges. I think that's it. Thank you.
All right, thank you. Would you like the question repeated?
Please.
Sure. Judicial resources are limited, and the practice of law is becoming more and more specialized, especially in civil court. Judges are being asked to decide matters that are often of first impression to the judge personally, and would be well beyond the experience of the vast majority of practicing lawyers. What role do you envision that outside legal resources, including continuing legal education, consulting with disinterested attorneys, or even the appointment of referees in certain matters, will play in assisting you performing the duties of circuit judge?
One of the challenges that any judge is going to have, especially when it comes to a new assignment that they don't have a lot of experience with, is tackling new legal issues or new areas of the law. No judge will be an expert in every area of the law. Some judges aren't an expert in one area of the law, like attorneys as well, and there's nothing wrong with that. What's important is recognizing when assistance is needed, when reliance on some other sources is needed. And I think any judge should be humble to the law and humble to an area of practice and understand when they may need additional resources. I agree with my opponent that any outside influence or outside resource must be thoroughly vetted, not just on the reliability of the data, but any bias and any aim or goal made by the people who created that. For example, I think of risk assessment tools that we use in criminal courts. Risk assessment tools may be the aim to objectify decision-making of judges, but that really goes against the foundation of a judicial principle that a judge must decide a case based upon that particular defendant and that particular set of facts. Also, those objective, and I use air quotes around that, objective risk assessment tools may be biased in that the data that goes into those tools produce biased results. I think ultimately a judge has to adhere to constitutional requirements to decide cases fairly and impartially outside of any undue influence. I can tell you what's important to note about my opponent in this case is that she has been willing to throw away constitutional ethics and constitutional requirements through participation in a diversity clerkship program that is using race-based decision-making to provide opportunities to some and not others. I think if we introduce race-based decision-making and DEI aspects into judges' roles, we're violating constitutional requirements.
Judge Sanborn, 30 seconds for rebuttal.
Thank you. So let me just start with the risk-based assessment. That's not considered an extra judicial resource in Waukesha County anyway. That was something that was created as part of an effort to respond to concerns about bail reform. So I don't believe that that is actually what we're talking about. We talk about an extra judicial resource. We were talking about things like law review articles or amicus curiae, things like that, where you really have a reason to be suspicious of where they came from and where they're going. With respect to my participation in a diversity committee, some of those,
30 seconds. 30 seconds.
oh, thank you. Some of you may know that my family is a member of the Choctaw Nation of Oklahoma. So when I'm asked to participate in a diversity committee, I see it as a public servant because I can have someone who's a conservative prosecutor make those decisions as opposed to being left out of it and letting woke individuals choose who is most qualified. Thank you.
Okay, I think that there was just a little bit of confusion in that it's 30 seconds total on a rebuttal. That's fine. We'll give you a full minute for rebuttal on this question, so a minute of rebuttal.
Sure. I don't disagree with the use of CLEs or outside education for judges. I've participated in lots of training statewide and nationally. When it comes to some cutting edge issues that judges haven't faced, I've dealt with a lot of those issues through Fourth Amendment and digital evidence. These are examples of aspects of the law that are coming up that the law and case law cannot keep up with. And I've been on the forefront of some of those issues. I can do that as a judge as well.
Okay, so we're on to the next question, and you will be answering this first, Mr.
Understood.
Okay, this question relates to the role of technology in jurisprudence. So-called artificial intelligence or enhanced web search programs such as ChatGPT are becoming widely used tools in the practice of law. Supreme Court Rule 60.04, sub 1, sub A, requires judges to quote-unquote hear and decide the cases before them. What role do you see AI programs playing in the judiciary performing its function of deciding cases, and should there be limits on that?
Well, this is a very timely question because just today, the statewide prosecutors network were invited to participate in an AI-enhanced Westlaw research program put on by Westlaw to talk about some of the benefits and some of the inherent dangers in using AI for legal research. And for those of us who have practiced in the law, we've read lawyer blogs and seen news reports about lawyers who are submitting briefs to the courts that are written by AI. They contain case cites that are not accurate. They contain quotes that are not accurate. And when we have judges who are not, doing their judicial duty and maybe writing their opinions based on AI, we're going to get the same type of problems with the judicial decisions. There are a lot of great uses for AI. It's a great starting point for public information, for publicly sourced information, for creation of ideas. I know I was in charge of putting together a trial skills course for prosecutors, and I had ChatGPT put together an agenda for me. And it's amazing what product can be pushed out just at the click of a button. Now, of course, you still have to tailor that to your individual needs. When it comes to legal research, AI has always been a part of producing results for the searches that we do in Westlaw and the legal sources. So AI has always been a part of the legal profession. What we have to be concerned about, I think, most is generative AI, where we're asking the artificial intelligence to create thought for us rather than return a bunch of set results. That's where the danger comes in. A judge has to ensure that any decisions are being made on the actual facts, not crowdsourced facts, and the actual law, not crowdsourced law. But it's important to know the difference between AI-assisted research and generative AI for creating these thoughts and ideas.
All right, thank you, Mr. Moss. Judge Schaborn, 2 minutes.
Thank
What would
you.
you like the question repeated?
No, I think I understand.
Okay.
Thank you, Kevin. So the way that I interpret the Supreme Court rule as a sitting judge is that I'm to decide the cases that come in front of me. That's what the rule states. Not to put the judgment in the hands of something else, like AI. So although it has amazing capabilities for lawyers and for other people in society, when it comes to judges, they are constrained by that rule. So I would look at it very skeptically. Thank you.
All right, thank you. 30 seconds for rebuttal, Mr.
Sure. I think we're on the same page for that. It's a valuable tool. It certainly doesn't replace judicial insight and judicial decision-making. So I think we've covered that topic.
Any further rebuttal?
No, thank you.
Okay, great. All right, the next question has to do with the role of precedent in jurisprudence. Judicial activism has been a very hot topic in the practice of law recently, with the current majority on the Wisconsin Supreme Court reversing a holding of the same court regarding drop boxes or absentee ballots that had been handed down just 2 years prior. And there is discussion of other previous holdings that may be subject to reversal, including the constitutionality of Act 10. What role do you believe that precedent should play in deciding matters as a circuit court judge? And do you believe the actions of the current majority of the Wisconsin Supreme Court have changed how a circuit court judge must view previous holdings of the court when evaluating precedent?
Thank you, Kevin. So in being a sitting judge in Waukesha County, I am guided by the teachings of former Supreme Court Justice Antonin Scalia, which means I start with the text. I start with the statute and I give it its plain meaning. That means that the rule of law comes first. Precedence takes a back seat. It is important in certain contexts to follow precedent, but to the extent that it conflicts with the rule of law shall be our guiding light. That is the statute. As a wise person that I know says, words have meaning. We give the words in the statute their plain meaning. Why is the statute important? Because it reflects the will of the people through the legislature. Because I, as a sitting circuit court judge, cannot make law. I follow law as enacted by the legislature. With respect to recent revisiting of Supreme Court decisions, I agree that the Supreme Court's change from 2020 to 2024 regarding ballot drop boxes was problematical. We have a liberal Supreme Court heading into the most consequential election of our time who reversed course. Why? What changed? The facts or the law? No. The makeup of the court changed, which is why we need conservative judges like Brad Schimmel on the Supreme Court bench and why you need judges like me in Waukesha County. Thank you.
Thank you, Judge Chambord. Mr. Moss, would you like the question repeated?
No, thank you. The role of precedents in jurisprudence is foundational. Without precedents, we have chaos among our laws, and that cannot stand. I agree that we have an incredibly important Supreme Court election coming up. I also agree that we had incredibly important Supreme Court elections recently. The flip of the court has produced some inconsistent results that I think we should all be concerned about. And I think all of you here tonight recognize the importance of April elections. But there's one person who apparently does not share that view, and that's my opponent. My opponent has been a regular November voter, but my opponent has not voted in any February primary or April election for as long as those records are available online, which goes back to 2016. Which means that my opponent has not voted in 6 of the last Supreme Court races. She has not voted for any of the Court of Appeals races, and she has not voted for the current terms of any of our county circuit court judges. So you cannot stand up here and trumpet the importance of constitutionality if you do not participate in the event, if you do not participate in the selection of those judges. I agree that we need conservative judicial values. The reason is because the conservative judicial values are the ones that adhere to legal precedent. We don't need activism. We don't need a Lynn Edelman overturning voter ID or rewriting the laws from the bench. A judge who, by the way, my opponent put in her application to Governor Evers that she most admires among jurists. That type of judicial activism may play in Dane, may play in Milwaukee. It does not play in Waukesha County.
Thank you. Judge Chambord, 30 seconds for rebuttal.
Yes, thank you. So unfortunately, my voting record has been incorrectly stated, and unless everybody wants to jump on my computer with me, we're gonna just have to call it like I do vote. With respect to activist judges, I'd like to point out that my opponent also applied for the Evers appointment and cited Derek Mosley, who's currently training the state in diversity, equity, and inclusion. So I think that's important for you to know. I also think it's important for you to know that he has a letter of support from Josh Call's office in his file. So,
That's 30 seconds.
oh, thank you. I think I've said all I need to say.
Everyone's voting record is available on My Vote. It's easy to look up. As for Judge Mosley in Milwaukee, I did admire him. I admire him for his connection to his community, and his teaching is not DEI, it's on unconscious bias, which is something that every prosecutor in the state and every judge should be trained on and is trained on. Unconscious bias is a training that is part of the judicial education that's delivered to all judges, and rightly so, because any judge must make decisions independent of bias and prejudice. And it's important to note that when making decisions.
All right, thank you, Mr. Moss. This question is to you. This relates to challenges to the Waukesha County bench. Based on your experience and research, what do you see as the biggest challenge facing the Waukesha County bench at this time? And what solutions would you propose to that challenge?
Well, I think there are a few concerns that I would like to highlight here. First and foremost is Milwaukee County and what to do about the surging crime that's coming through Milwaukee County and into Waukesha County. It's unfortunate that the mess that is created and fostered in Milwaukee County must be supported or must be dealt with by Waukesha County judges. So the question is, how can the judges here best address that? We have to recognize that any resources in the court system, the sheriff's department, the police, the jails, the prosecutor's office, and the defense attorneys are all finite. So we have limited resources with which to deal with these problems. A judge plays an important role in the allocation of those resources through sentencing. So if we have similarly situated offenders, one from Milwaukee, one from Waukesha, and they come into this community, commit crimes here, we have to determine who among the Waukesha County residents may be rehabilitated to help with the recidivism, and who on the Milwaukee side of things need to be punished so that it is no longer cost beneficial to come into Waukesha and commit these crimes. Different resource pools, different allocation of those, and we have to make decisions that keep the crime out through really punishment, because we can't waste our precious resources on trying to rehabilitate some of these people that don't even live in the community. The other area of concern is this trend towards turning Waukesha more purple and blue. This trend is concerning. We have too many liberal viewpoints, some among the judiciary, that are running on a platform to change our laws, including a Supreme Court candidate or a candidate for Supreme Court. That type of change just will not play in Waukesha, and we have to ensure that we have known conservative quantities, people who would know candidates and know that they bring those conservative values to the bench. That's why I'm running, because I'm a known quantity among your trusted officials to bring and maintain that conservative viewpoint from the bench.
Can you please repeat the question?
Absolutely.
Thank you.
This relates to the challenges to the Waukesha County bench. Based on your experience and research, what do you see as the biggest challenge facing the Waukesha County bench at this time? And what solutions would you propose to that challenge?
Thank you. So the biggest challenge facing Waukesha County right now is Milwaukee County. And my opponent would know that. He worked there for over 5 years, I think, before going to Dane County. And Milwaukee County is a broken system. Milwaukee County will not hold criminals accountable, and the problems will bleed over into Waukesha. We can't fix Milwaukee County. What can we do? We can hold criminals accountable. I will tell you right now, as a sitting judge, what I am seeing. The DA's case numbers are up. More cases are being charged. I have more than 600 cases on my docket right now. This is an issue that needs to be addressed. I saw it as a prosecutor and I see it as a judge. And I'm just going to tell you quickly about those examples. When I was a prosecutor, I would get called from agents who were working cases in Milwaukee. They would say, I can't get this dangerous defendant detained without bail going into sentencing. I can't get the sentence that I want. Can you adopt this case? Can you take it from the state? Can you get this contract killer Randy Johnson detained? Yes, I can. Yes, I can convict him. Happy to do that for you because Milwaukee County is broken. I know how to do this for Waukesha County too. I see it as a judge. There are people who appear in front of me who have prior Milwaukee County cases, 3rd, 4th, and 5th offenses that are not getting jail sentences. Partially because of work done by my opponent and his colleagues in the Milwaukee County DA's office. So what do I do about it? When they come into my courtroom, I hold them accountable because I refuse to be party to a failure of the state system. I will not let Waukesha County turn into that. We deserve more. Thank you.
Mr. Moss, 30 seconds.
Thank you. Yeah, Judge Shaneborn has 600 cases, and if I had to guess, that's probably an underestimation. I have about the same number of cases assigned to me in my branch in Fond du Lac. I mean, prosecutors are absolutely swamped, and courts are absolutely swamped, and it is a, it's a crisis, not to be too hyperbolic. So those of you who have influences with your legislature, I'll do a quick pitch for DA funding and court system funding, because that type of caseload is really unsustainable, and it's a strain on judges and prosecutors.
Judge Shaneborn, 30 seconds.
No, thank you.
Okay. Next question relates to the judiciary role in the criminal justice system. I'm going to have to be reminded who I'm going to here. Okay. This question is...
Oh, wait, no, I'm sorry. It is Judge Shane.
Okay, we're over here. Sorry. I'm going to get my pay docked. I apologize for that.
Whatever they're paying you is not enough.
Double.
Yeah.
So, can you please comment on your view of the effectiveness of diversionary programs that have been developed for drug offenses as well as domestic abuse offenses? And do you see a role for other types of diversionary programs, such as for mental health issues?
Thank you. And is the full question the role of the judge in the criminal justice system? Did you start there?
Yes, this would be the role of the judge in the criminal justice system.
Okay, thank you. So let me just start out by saying it's a preliminary matter. The role of the judge in the criminal justice system is to protect the community. That is baked into the case law at sentencing, the galleon factors. It's based into the statute. So that is our job in criminal court. The role of the judge is to protect the community. Bail, sentencing, everything in between. With respect to Kevin's question, is there room for diversionary courts? For example, mental health treatment, drug treatment, etc. I think there is room for those. I think there is support in the community. I preside over a drug treatment court. That was an assignment that I was given when I started in Waukesha County, and I have seen some really great successes. However, we need to limit the scope of its applicability, and we need to understand that it is not for everyone. Nonviolent offenders, users, not drug traffickers, gun toters, acts of violence, etc. The other part of the question is, can there be more treatment courts? Theoretically, a mental health treatment court. Theoretically, a veterans treatment court. They sound wonderful. The devil is in the details. Is there support for it, and is there a need? And where will there be money for it? Where are the resources? Because Waukesha County does not have finite resources to do its primary job of protecting the public. It has finite resources, I'm sorry. That is our primary goal. So we start there. Is there room for a treatment court? There can be, but it does have limited applicability. Thank you.
Thank you, Judge Shaneborn.
If I could get the question again, please.
Absolutely.
Thank you.
This is about the judiciary role of the criminal justice system. Please comment on your view of the effectiveness of diversionary programs that have been developed for drug offenses as well as domestic abuse offenses. And do you see a role for other types of diversionary programs, such as for mental health issues?
I'm also the district attorney's representative on the Fond du Lac County Drug Treatment Court as well, which was an assignment I was tasked with when I joined that office. And I can speak firsthand that I agree with my opponent that there are benefits to a drug treatment court. It addresses specific needs. It attempts to rehabilitate the offender with very hands-on approaches to treatment and accountability. The issues are a few, though. Number one, any drug treatment court like ours is going to be specifically for high-risk, high-needs offenders. That introduces a problem because the only people who are high risk are the ones who have prior drug offenses or prior criminal offense histories. You're looking at a target population that otherwise, but for the intervention of drug treatment court, would be going to prison. High needs is problematic as well because they need intense treatment and supervision. And when it comes time to hold these people accountable, you have a lot of different hands in the pot, all with different motivations. You have the prosecutor who wants to seek justice. You have treatment providers who want to, help rehabilitate the person. You have Department of Corrections, probation, and parole agents, which, speaking of some issues in the criminal justice system, probation and decisions on revocation is a separate issue. But everyone may be pulling in different directions, and it's sometimes hard to hold these people accountable. I do think there is a great need for mental health treatment court. I'll give you a quick story. I had two parents bring their adult son to a hospital in Fond du Lac for a mental health commitment. The hospital rejected him because he wasn't high risk enough. So they went back in the parking lot, and the son was trying to put water into the gas tank because he thought the car ran on water. So the security guards came out, they tackled him, there was a fight, the police showed up, and they had to arrest the son on domestic violence charges because he fought with his father, and they had to refer charges to the DA's office. That's not a case that's appropriate for the criminal justice system. Some sort of mental health option there, or diversion, would be best for that defendant.
Okay, thank you. 30 seconds.
I have nothing to add, thank you.
Okay. All right, let's move on to the next question, which is background and judicial temperament. And I believe this question is to Mr. Moss. This is a three-part question. Why did you first seek to become a lawyer? What is the biggest influence on your decision to become a judge? And what is the most important thing you hope to accomplish as a judge?
Could I get that last part reread?
Sure.
Those three factors, or the three questions?
Why did you first seek to become a lawyer? What's the biggest influence on your decision to become a judge? And what is the most important thing you hope to accomplish as a judge?
Okay. Thank you. So why did I first seek to become a lawyer? I was a performer at heart. I loved acting, but I also liked getting paid. And actors don't get paid, lawyers are paid actors. So that was kind of what really brought me to the legal profession. What I didn't expect was to fall in love with criminal justice. I worked for 1 year at a civil law firm doing civil litigation. I got into a courtroom once on a frivolous motion that a partner filed. And that was not, to me, that was not the law. The law was getting up in front of people. The law was advocating for a party. The law was representing someone and making their arguments. So I went into criminal law because that's where, the action was for a trial attorney. And I really fell in love with criminal law. That became my passion. So what started out as, well, I'll do this for 3 years and get some experience, quickly became a 25-year career. And I've loved a lot of the aspects of being a prosecutor because that was lawyering to me. What was my biggest influence on my decision to be a judge? Really what it was when I was traveling around the state and going to different counties, seeing cases not be heard by judges. And what I mean by that is judges not paying attention to arguments, judges not being prepared, judges not thoroughly reading briefs, things like that. To me, that's a real failure as a judge, a failure or dereliction of duty. You have to be prepared, have to read things, you have to work hard. And I always thought when I encountered those judges, I would do a better job than that. And that was important for me. The most important thing to accomplish, I want to end my term after 12 years as a circuit court judge knowing that I've protected the community. That's ultimately what I want to accomplish. I want people to look back at my 12-year career and say, Judge Moss protected me, protected the community.
Would you like the question read back, Judge Shane?
I think I have it sufficiently in mind,
Okay.
thank you. So why am I a lawyer? Well, I'm the youngest of 7 kids, and from a very young age, I had a strong sense of justice or injustice ingrained in me. and it really has not come out. It really, yeah, much to lots of people's chagrin. So my opponent mentioned a Judge Edelman that I used to appear in front of, who I cited in my materials as a judge that I, for a very long time, had a really healthy and robust disagreement with. We usually disagreed as to the outcomes, but I always got to zealously advocate in front of him. And one of the stories I want to tell you is, we were back in his chambers. I knew that the decision was going to go poorly for the United States. There was a defense attorney, myself, and the judge. I got really heated. I made my arguments. I'm the youngest of 7. I'm ready to go. I go out into the courtroom, and the bailiff, a famed hero and MPD who was retired and was now his bailiff, he said, "I could hear you yelling." And I said, "Yeah." He said, "Everybody could hear you yelling." I said, "Daryl, I'm not going down without a fight." So it was, yeah, it's in my blood. By the way, I should clear up the record. He's not my favorite judge. Judge Aranda is my favorite judge, for those of you who know him. Great guy, Vietnam veteran, amazing. Influencing. I will tell you, 2 judges, Judge Pepper and Judge Jones. I have not called them out by name before, but I can't tell the story without calling them by name. Judge Pepper, heading into sentencing, asked her to detain defendants without bail, which was required by the statute. She would look at me and say, "AUSA shame board, I know what the law says. I'm not going to do it." Another example, Magistrate Judge Jones, prosecuting an illegal alien, 6 firearms, 3 kilos of cocaine, and an ICE detainer. Detention under the statute. Judge Jones detained him. I'm going to go off the bench, Judge Jones, and call ICE to see if the detainer can be lifted. My legacy, protecting this community, preventing it from turning into Milwaukee County, and making it a great place for my kids to raise their kids, and not just for 12 years. I'm here forever. You got me. You can't get rid of me.
Mr. Moss, 30 seconds.
Judge Edelman might not be your favorite judge, but it's the judge she cited as the one she admired in order to get a liberal governor to appoint her as judge. So what does that tell you? And Judge Edelman, what I'm reminded of when I think of his legacy, is calling out the Roberts Supreme Court in a law review article and getting censored by the Judicial Council in the 7th Circuit. That's the legacy of someone like Judge Edelman.
Judge Seymour, 30 seconds.
Sure, if you were to cherry pick my application and you pick that one out, it would be a misconstruing. What's the word? A lie can get halfway around the world before the truth can get its boots on. Happy to talk to you more about that later. The other thing, who's your biggest contributor? Ellen Brostrom, who supported Jenna Prosewitz over Dan Kelly. So I don't know that we want to go there. I'm done, thank you.
Okay, next question relates to the judiciary's role in alternative dispute resolution. Okay, once again, the practice of law is becoming more and more specialized. When the concept of judicial, oh, I'm sorry, I skipped ahead, sorry. Leaving aside criminal matters, what do you see as the judge's role in facilitating alternative dispute resolution or settlement in a matter, and does that change depending on the type of matter or the parties involved?
Thank you. Great question. So, as you indicated, there is a rule that prohibits alternative dispute resolution, or ADR, being used in criminal cases. Why? It wouldn't protect the public and other things, like it wouldn't acknowledge victims' rights under Marcy's law. The other caveat for ADR, it cannot be something that the judges use to supplant their judgment for what the parties want. ADR is non-binding unless the parties agree that it's binding. What is it beneficial for? As a judge, I believe that the citizens of Waukesha County should have meaningful and effective access to the courts. What are some of the challenges? Litigation is time-consuming and it's expensive. ADR can be responsive to those concerns to the extent that the parties are willing to participate in, and also can help them with subject matter areas that are particularly challenging. So I would say this, great idea in theory, a couple caveats. Not to be used in criminal law, and not to be used for something where the judge can supplant their decision and impose something on the parties that they do not want. Thank you.
Thank you, Judge Seymour. Mr. Moss.
I largely agree with my opponent on that. I think it's an effective tool. I think it helps reduce some of the financial barriers, especially to pro se litigants who might not otherwise be able to be in a civil lawsuit for the long haul. It can also provide a faster resolution to cases, which is a significant problem in civil court as well. So I agree. I think ADR should be encouraged by judges. It should be used with the same caveats that Judge Chamborn said. It does not supplant the role of a judge in litigation. I also think that any ADR has to ensure that there's accountability and transparency in that process. ADR should not be used in a situation where there is a public dispute and the litigants are seeking alternative dispute resolution simply to resolve a dispute behind closed doors. I think that's another caveat that we would seek to avoid with ADR.
Thank you, Judge Chamborn, 30 seconds.
I have nothing to add, thank you, Kevin.
Mr. Moss?
Nothing else.
All right, thank you. Okay, next question. This has to do with judicial rotation. Once again, the practice of law is becoming more and more specialized. When the concept of judicial rotation was introduced over 40 years ago, lawyers would routinely handle matters across the board, conducting trials, authoring corporate documents, handling family matters, etc. Do you believe that judicial rotation is still an effective mechanism that should be employed in the management of the courts? If so, why? If not, why not?
Well, I've had the experience now from practicing 9 years in the Milwaukee District Attorney's Office in a county with 40+ branches and specialized courts, to practicing currently in Fond du Lac County District Attorney's Office with 5 branches where every judge does every type of case. I think there are advantages to judicial rotation, and I think it helps foster a well-rounded and a well-functioning judiciary. First, I think it actually enhances judicial expertise. Rather than having to handle all cases at all times and trying to be a jack of all trades, master of none, a judge can focus on one area of the law and really dive deep into that and learn that subject matter. Now, I say one area of the law, recognizing that maybe family court is still a large area or criminal court is still a large area of law. But there's also something to be said for hearing the arguments of seasoned attorneys who specialize in those areas of law as well. There's nothing wrong with listening to the experts, and often the experts are the ones who appear in court and litigate those cases day in and day out. Judicial rotation has a lot of mental health effects too for judges, good mental health effects, I mean. It helps avoid burnout. A judge stuck on criminal rotation for years and years and years, or a judge stuck in family court for years and years and years, is probably going to eventually succumb to some of that secondary trauma. I know first well, having specialized in internet crimes against children cases for about 10 years at the Attorney General's office, the effect of those types of cases can have on investigators and prosecutors and courts, and frankly, juries who have to come in and hear those cases. So judicial rotation helps with that. And then finally, I think it helps with promoting impartiality and preventing specialization bias. A judge doesn't just simply rely on tried and true methods, tried and true case laws. A new judge coming in may help innovate the practice and the way those cases are handled.
Judge Chamborn.
Thank you. So, Waukesha County is a county where when a judge is elected, they are elected to a branch, but not a type of practice area. So they will rotate every couple years. It's not a firm number, but it's roughly 2 to 4 from branch to branch. Civil, criminal, juvenile, family. Unlike some other states where judges run for a particular branch, they run for criminal, and that's where they serve. Why is this important? Number one, I have strong civil and criminal experience. I was a law clerk for 3 years, working on issues of constitutional import. I plugged and chugged claims arising under the First and the Second, the 8th, and the 14th Amendments. I have civil litigation as a practitioner doing, among other things, discovery, request for production of documents, summary judgment motions, where the majority of civil claims are resolved. I am ready to serve in civil when I am called to go there. Currently, obviously, I serve in criminal. I'm an expert in criminal by virtue of the work that I did before I got here. Again, prosecuting members of dangerous drug cartels who are bringing hundreds of kilograms of controlled substances across our border, street gangs who are ruining our community with their gunplay, violence, turf wars, and distribution of powder cocaine and crack cocaine, and criminals who sought to deprive our elderly out of their hard-earned gains by committing financial crimes against them. So I'm well-suited in criminal, I'm ready to go in civil, and I will learn when I rotate into the others. I will submit, though, wherever you are as a judge in Waukesha County, the most important thing that you need, follow the rule of law and a good judicial temperament, which means being patient, which means being kind, which means treating people with respect and making them feel heard. Thank you.
Thank you, Judge Shane Warren. Mr. Moss, 30 seconds.
Thank you. My opponent has more civil law experience than I do. My civil experience was a year in a private firm and then doing some quasi-civil criminal cases, like a year on the termination of parental rights cases, which are very civil in nature, and several years supervising the sexually violent persons commitment case load at the Attorney General's office. But I have far more criminal experience than my opponent, including far more state circuit court experience than my opponent.
30 seconds for a vote.
Thank you. Well, to the extent that my opponent is arguing that I am less qualified because I served as a federal prosecutor before I came here, it's working out pretty well for Supreme Court Justice Annette Ziegler, who went from the U.S. Attorney's Office to the Washington County bench before being on the Supreme Court. So I'm sure that's not what he's arguing. Second, judges who have business experience are needed on the civil bench. Business owners in Waukesha County matter, and they want judges who preside over their cases who know what they're doing, who are familiar with financial cases and summary judgment motions. Thank you.
All right, we have reached the final question of the evening for this portion of the debate. And this has to do with the constitutional role of the judiciary, in particular how it relates to election integrity issues, but it can also apply to all other issues as well. Organizations and persons who have litigated election integrity matters across the state have routinely faced situations where, when challenging the actions of the executive branch vis-a-vis the fulfillment of legal duties, judges are extremely deferential to arguments made by the state in defense of the executive. I will make an exception, though. The Waukesha County judges have been great about this. So, elsewhere, what do you believe is the proper role of the judge in evaluating whether the executive branch has complied with its statutory duties related to the administration of elections? And I believe it's your question first for 2 minutes.
Thank you. So let me start by saying that election integrity is something that affects us all. Voters need to believe that their votes count and that they're being made in a fair and reliable system. Prosecution of election fraud cases is important, and I will apply the well-established rules of the Supreme Court and the guiding statutes. However, I would submit that election fraud cases dealing with the executive are the tip of the iceberg when it comes to election fraud. What do I mean by that? We have institutional challenges, drop boxes, coercive absentee voting, challenges to the voter ID law. Our resources can also be directed there, and guess what? Those happen on the front end, not on the back end after the election fraud has already occurred. And I've said it before and I'm going to say it again. With this activist, liberal Supreme Court, we can elect Brad Schimmel as a conservative who will follow the law. This court has indicated that they will not hesitate to take up election laws in order to change them. That is wrong. That is for the legislature to do, not an activist Supreme Court. Thank you.
Thank you, Mr. Moss. 2 minutes.
Well, I've prosecuted election fraud cases. When I started at the Attorney General's office in 2008, J.B. Van Hollen put me on his election fraud task force, and I worked with our Division of Criminal Investigation and prosecuted ACORN special registration deputies. You know, those were those people who were going around signing people up to vote by pulling names out of the phone book just so they could get their $25 a day. I prosecuted those people. We prosecuted felon voters. We prosecuted double voters. We prosecuted people who were voting outside their district and their area. I know what chapters 5 through 12, the election laws, look like in Wisconsin. I think they need a rewrite, but we were able to make it work to prosecute the election fraud when we were under an administration that wanted to look for it, that went out and found it and prosecuted it. When Brad Schimmel took over as the Attorney General, he put me in charge of the election fraud task force. As I said in my opening, I literally wrote the book, The Prosecutor's Manual, for all of the DAs around the state to guide them in prosecuting election fraud. Most of those offenses, though, are charged and prosecuted by the district attorneys, not the Attorney General's office. But I've been there. I've been on the front lines. I've seen election fraud. And by the way, that election fraud monitoring of the polls stopped in 2018 under Josh Call. So I can tell you firsthand that it is out there and it needs to be prosecuted vigorously. We need judges who have experienced it, who have seen it, who knows what it looks like, and can respect it when those cases come in front of the court. We also need to make sure that, you know, this idea of ensuring the only qualified electors can vote by removing all election protections is not the way we ensure that only qualified electors can vote. There's nothing wrong with protections put in place like voter ID to ensure that only the people who are qualified to vote can vote. So we need to protect against that mentality that we just remove all protections in the name of fairness.
Judge Shamborn, 30 seconds for a vote.
I have nothing to add, thank you, Kevin.
Thank you. Mr. Phillips. All right, well, we have reached the end of this portion of the debate. At this point, Kathy Pape will collect any questions that anybody has. If anybody has any, we'll collect those, and then we'll take about a 10 to 15-minute break here. I'll review the questions, and we'll come back. And if we don't have any questions, we'll go straight to closing statements. If we have questions, we'll have them.